Well, I would just point out to the gentleman from Missouri that there has been a lot of confusion about what is in the manager's amendment and what was included in a separate amendment that I had considered offering but did not offer during this proceeding or during the markup last week. That amendment addressed specifically the issue of the Graves Amendment, and it's very important for everyone to understand that the language included in the manager's amendment does not include any section regarding rental cars, nor does it relate to the Graves Amendment. The language in the manager's amendment is completely separate and distinct. And to my knowledge, there were not any regulations that were issued by the NHTSA during the time frame that's covered by the manager's amendment dealing with the issue of rental cars. So I'm more than happy to respond to the underlying basis for the amendment, which is to restore the doctrine of federal preemption that existed for over 100 years before George Bush became president, and federal agencies started usurping the proper role of Congress in a federal scheme by allowing unnamed federal bureaucrats to initiate the doctrine of preemption without any express direction from Congress. That is the purpose of the language that was included in the manager's amendment.
So what about the section, Mr. Braley, on what does this mean during the years 2005 and 2008? I think I just heard you say that there were no regulations issued, so why would we want to see that they couldn't finish?
No, that's not what I said.
Okay, well, I'm not trying to be difficult. I'm just trying to understand.
No, you brought up two separate issues. One is the general federal doctrine of preemption, which is the focus of the language in the manager's amendment. You also referred to the Graves Amendment, which is a very defined amendment dealing with the rental car industry. I had originally proposed two amendments to the committee. One dealing with the impact of the Graves Amendment, one dealing with the general concept of federal preemption during the time frame that you have been describing. That is included in the manager's amendment. The language dealing with the Graves Amendment is not included in the manager's amendment, nor did I offer that amendment, and I do not intend to do so. So I'm just trying to make sure you understand, Mr. Blunt, the concerns that may have been raised to you about the impact on the Graves Amendment, in my understanding, are not covered by the intent of the language included in the manager's amendment. I do have a list of the regulations that NHTSA, which is the very narrow focus of the language included in the manager's amendment now, regulations that they did issue during the time period involved, and I don't see any regulation dealing with the rental car industry. So I don't know how the Graves language could be impacted by something we're doing that addresses those specific regulations.
And would the principle be the same, that the industry should have been able to act on those regulations and move forward based on those regulations that we now say would have no effect, whether it was the rental car industry or some other industry? Well,
this only deals with the actions taken by NHTSA within their statutory framework. So I'm not aware of the role that NHTSA plays in regulating the rental car industry. I'm not prepared to tell you whether that would have an impact on something that has already taken place. But clearly within the regulations we've identified during this time period, I see nothing that directly relates to the leasing of rental cars.
Gentleman's time has expired.
Would the gentleman yield?
I yield to Mr. Braley.
I want to thank the chairman for yielding, and it's also important to note that this amendment is consistent with President Obama's executive order that he issued the very first day or very first week in office, rolling back this practice that developed under the previous administration of usurping the function of Congress, which is the proper role of federal preemption. Congress, not a federal bureaucrat under the doctrine of preemption, has the authority to preempt state law. The language in the manager's amendment protects American families, upholds state rights, and ensures the will of federal elected officials will prevail over unelected bureaucrats. Prior to 2005, NHTSA always believed that both federal regulation and state tort claims are necessary to protect consumers. But during the period of 2005 to 2008, unelected bureaucrats at NHTSA issued numerous safety regulations with preamble language claiming that those regulations adopted by bureaucrats, oftentimes without public comment, preempted state law claims. And they based it on a Supreme Court decision in 2000, Geyer versus Honda Motor Company, and the Supreme Court subsequently disagreed with that practice in the case of Wyeth versus Levine, which was handed down last year, and said that federal agencies cannot cite to the Geyer case to claim preemption. This language ensures that these nameless bureaucrats are not given the power of Congress to determine when we preempt state law. The language of the manager's amendment is clear that Congress still has authority to preempt state law, but it is Congress's role, not an unnamed, faceless federal bureaucrat, to do that. And to get to Mr. Blunt's point, the language that was already adopted in these regulations is still as admissible as evidence that these manufacturers met the appropriate standard of safety at the time those vehicles were placed in service. So it's still going to be admissible as what the appropriate standard was, and therefore there will be no elimination of those regulations as a defense that these products met the state of the art at the time they were placed in service. And in almost every product liability claim, the defense of conforming to the state of the art at the time the vehicle was placed in purchase is an absolute defense to liability. So the regulations still have an important role. We are not throwing them out, and we're just reinstating the role that Congress has played under the doctrine of preemption since this country was founded. And with that,
if I can reclaim my time,
I'll yield back.